Is Tibble over at this point? What comes next?
No, it's not over. The case is continuing. It's been remanded back to the lower courts for follow-on proceedings. But in terms of the duty to monitor, the argument was made that the sky would fall, as you pointed out, if the court went our way. The court went unanimously in favor of the plaintiffs in the case and felt that the sky by no means will fall. It will not fall. Frankly, the duty to monitor investments that are already in a plan for fees and performance will take about a minute because it's on a chart. And it isn't the same duty that you have when you're selecting funds for inclusion in a plan to look at funds as to whether they should be continued in a plan. Fees and performance are readily available by any fund manager. And so if the fees were reasonable and they remain the same, then they're reasonable. And if the performance is appropriate, then you've done monitoring. You've done the things you need to do. Whether there's some other monitoring that should be done, the courts may clarify that. But the basic duty is one of anybody who's simply looking at investment performance and fees on a repeated basis.
Why do you contend what ABB and Fidelity did is so egregious?
ABB was the first and only full trial of a 401k excessive fee in the history of the country. In that case, Fidelity was the record keeper for the 401k plan, had investments, retail fund investments on the investment menu, but also was the record keeper for a defined benefit plan for the company executives, for the health and welfare plan of the company, and did payroll processing. We alleged, and the court found, and it was upheld by the Court of Appeals, that Fidelity was providing the company services, the corporate services for the 3 corporate plans at a loss, while the 401k plan was being provided by Fidelity at a 51% profit, meaning the employees were paying to subsidize company expenses. That's not a sleep at the switch. That's frank self-dealing, and that is absolutely prohibited. You can't benefit yourself at the expense of your employees.
What is the structure and the mission of your firm?
We only represent individuals. We don't represent any companies or insurance companies. And we represent people who are injured. We represent people who are victims of financial abuse or defective pharmaceutical products and things of that nature. But what we do is we invest with our clients. I've never sent an invoice in my career to anybody. I've worked 2 hours, send me money. That's not what we do. We invest in the case because we believe in the case, and just as with these cases, if you don't believe in your case, if you don't have conviction and passion for your case and your client, you shouldn't be handling the case. When you make that investment and you have expert witnesses and lots of time, if you don't win for your client, you don't get paid. And all that time and all that cost that you put out is lost. Because the key to the courthouse for the average little person to take on a corporation is that contingent fee where you're only paid if they win, because they don't have the money to put up and pay an hourly rate. So that's what I've always done. That's out of conviction that that's what I want to do with my time. And as a result, we've done this for the entire duration of the firm. We're proud of what accomplishments we've made, and we're very proud of the fact that fees have come down in the 401k industry across the board, not simply in the cases we've had. That's a benefit to American workers and retirees. That's very gratifying.